Good day, everyone. This is Arugu Speaks on Arugu Insights. Today, we'll look at topic, the sources of law in Nigeria. And for us to start, let me begin with this anecdote. The sources of law in Nigeria can be compared to a king with multiple wives. One is a Yoruba woman. The other one is an Hausa Fulani woman. The other one is the third wife is an Igbo woman. The fourth one is a woman from the Niger Delta. And then perhaps the fifth wife is a woman from Benin Republic. In a home like that, it is difficult to say with certainty how the laws will apply. The woman from Yoruba would want the son to greet the king bowing down. In Igbo land, they don't bow down to a king. You show respect to your king. The child that was from the mother from the Niger Delta can even call the king, bros, how you doing? With familiarity and all of that. That's how the sources of law in Nigeria are, from a very pluralistic paradigm. You know, we got independence from the British, and the British came with their own laws. They came with the names we bear today. My middle name is William, and some are bearing Bernard, some are bearing Maxwell, some are bearing that. And then they came with their religion and all of that. That one affected us. Another thing that affected us is that there are over 250 ethnic groups in Nigeria, and of these over 250 ethnic groups, they came with different customs. The way the Bini people behave, their reverence for traditional institutions. The way the Yoruba people behave, their reverence for custom and tradition. The way the Hausa people behave, their reverence for their religion and their way of life. The way the Igbos behave, their enterprising nature and their hard-working culture. The way the Niger Delta people behave, they are full of entertainment and glamour and fun. Of all of this, we make one country called Nigeria. And so the sources of law differ. One is Nigerian legislation. This comprises of statutes from the National Assembly, the state, and subsidiary legislation, with the Constitution as the apex law of the land. One, the Constitution is the apex law of the land, referred to as the ground norm in Section 1 of the Constitution, the basic law of the land. That is a settled matter in Nigeria. It is basic because for every law to apply in Nigeria, it must conform with the provisions of the Constitution. If it doesn't, to the extent of that inconsistency, it will be declared void. Look at the decision in Abia State and Attorney General of the Federation, where the courts clearly stated the Constitution as the ground norm. Then you move to federal and state statutes. Federal statutes, the Constitution has divided the duties among the tiers of government. Matters are kept that are exclusive in nature, that is within the legislative purview of the National Assembly. Matters that are concurrent in nature and matters that are residual. Matters that are exclusive are issues of defense, policing, and then incorporation of companies and all of that. A clear case of relating to business, it's the Companies and Allied Matters Act that we'll be talking about very well in this lecture series. So you come to discover that matters about companies, the state cannot talk about them. And then you go to issues about chieftaincy, states can talk about them. Issues of education, those ones fall within the ward, matters that are concurrent in nature. And so the states can deal with them. Now, we move to issues of subsidiary legislation made thereunder, the laws already made by the states or the federal government, subsidiary in nature, they are secondary in nature. Not though made by the the assembly or the National Assembly, but those implementing the laws, like you have the CBN regulations and all of that. But for the subsidiary legislation to apply, it must conform, it must go within the ambit of the enabling law. If it exceeds that, then the law is inconsistent. It goes to an area where the main law couldn't go. A clear case where the Supreme Court stated that is the decision of the Attorney General of Lagos State and Echo Hotels, where the Supreme Court set aside a regulation by the Lagos State government because it went beyond the legislative purview or ambit of the Lagos State government. Nigerian legislation is the primary source of law in Nigeria, with the Constitution as the basic law, and every other law gains legitimacy by agreeing with the provisions of the Constitution. The second source of law in Nigeria is received English law that was introduced into Nigeria by the Supreme Court Ordinance of 1914. And the received English law has three limbs: statutes of general application, principles of common law, and doctrines of equity. For them to apply, for these three limbs to apply, for any of them to apply, it must conform with the Constitution of the Federal Republic of Nigeria and our peculiar local circumstances. If it doesn't, it will not apply. Statutes of general application were statutes of general nature that were in operation in England as of 1st of January 1900, and include statutes like the Statute of Frauds 1677, the Wills Act 1837. For them to apply, for the statutes of general application to apply, they must conform or agree with the provisions of the Constitution of Nigeria 1999 and the prevailing local circumstances. Again, if there is the existence of a local ward statute, the statutes of general application will not apply. If you look at the decision of the courts in Young and Abina, it applied. But if you look at the decision of the court in Balogun and Oshunkoya, the court said that for the purpose of fairness, the statute of general application will not apply. The second limb of received English law is common law, which is a product of English judicial precedent, covering areas like law of contracts, torts, and all of that. It is applicable in Nigeria, but subject to what? The availability of local statutes on that area. A clear case in point is the case of Lewis and Bankole. The court applied customary law to resolve a land dispute in Nigeria, showing its relevance in Nigeria. But in Amoju Tijani and Secretary Southern Nigeria, the Privy Council prioritized customary land tenure system over the more established principle of absolute ownership of land. That's a clear case where the courts have shown that for the principles of common law to apply, they must not only be available, but that they must be compatible with the local circumstances. The third limb of the received English law are the doctrines of equity developed by the courts of chancery in England, and they come up with remedies like injunctions and specific performance. In Nigeria, equitable principles have been applied in several cases. You go to court today, you hear of injunction and that and that. A clear case is the case of Esiaga and the University of Calabar, where the court used equitable remedies to grant injunction. And then in the case of Okonkwo and Okagwe, the court, in agreement with the principles of equity and in line with Section 42 of the Constitution of the Federal Republic of Nigeria 1999, set aside the obnoxious customary practice that denied women inheritance. The constitutional legitimacy or basis for the legitimacy of received English law is Section 315 of the Constitution that preserves existing laws, a clear case is received English law. And so, if anyone argues that received English law is illegitimate, make reference to section 315 of the Constitution. But they must be subject to constitutional scrutiny, ensuring their subordinate word status. The third source of law in Nigeria is case law. And you know that section 6 of our Constitution vests judicial powers on the judiciary. And in Nigeria, there are a plethora of courts, the Supreme Court to the Court of Appeal, to the courts beneath them, the High Court, the Federal High Court, the Customary Court of Appeal, the Sharia Court of Appeal, the National Industrial Courts, and all of them. In this arrangement is the doctrine of that lawyers call stare decisis, staying by what has been decided. A decision of the Supreme Court, which is the highest court of the land, is binding on the courts below, the Court of Appeal, and the other courts. If there is no decision of the Supreme Court on the matter, a decision of the Court of Appeal is binding on the lower courts beneath the Court of Appeal. That is the arrangement. It is the duty of the courts to fill the gaps in our legislation. So they interpret the laws to make sure that the laws rhyme with the intention of the lawmakers. That is the rule of case law in Nigeria. What then is the rule of case law? Fill the gaps. A clear case is the decision of the Nigerian Supreme Court in Dapian Long and Darie, where a governor that had been impeached was returned back to office by the Supreme Court. That tells you the power of our courts. In Attorney General of Bendel State and others, and Attorney General of the Federation, a federal government purported law was set aside by the Supreme Court. I remember the glorious days of the Nigerian Supreme Court, those days when the Supreme Court could just sit down and close their eyes and do what is right. The fourth source of law in Nigeria is customary law. A customs, a country with over 250 ethnic groups. You can see the number of customs and all of that. And so, these customs, some are so bad. The clear case in point is the issue where women are denied their basic rights in the name of custom and all of that. The custom where you can sacrifice a human being to a god that nobody can see and all of that. And so all of those customs. When will customary law be valid in Nigeria? For customary law to be valid in Nigeria, it is meant to pass through the crucible. It will pass through three tests. Number one, it must not be, the custom must not be repugnant to the principles of natural justice, equity, and good conscience. 2, it must not be contrary to public policy. 3, it must not conflict with the Constitution of Nigeria or any other written law in Nigeria. In Ogunwumi and Oguneson, the Supreme Court upheld the customary land tenure system that made this test. In the earlier case we talked about, in Okonkwo and Okagwe, the Supreme Court set aside the obnoxious custom that denied women from benefiting from their parents by way of inheritance. In Omeribe and Egu, the Supreme Court said that for custom to be declared valid, you must lead evidence to show that that custom does exist. A testament to the fact that the customs vary from one place to the other. The fifth source of law is law reports. This is peripheral or secondary in nature. This is a follow-up to case law as a source of law. When the courts of law pass their judgment, the judgments are reported in law reports. Some of the major law reports are the Nigeria Weekly Law Reports, all Nigeria Law Reports, and the rest of them. What is their relevance? The moment these laws are distilled into writing, it is easier for people, lawyers and non-lawyers, to have access to them and know what is the reasoning, what you call the ratio decidendi, or the other things the court talked about, the obiter in the matter, what the court talked about. So it gives lawyers and non-lawyers the opportunity to know what the court talked about, so it is treated as a source of law in Nigeria. The final and the last source of law in Nigeria is textbooks. Textbooks, authored by some of the best brains the country has produced. Theo Elias, Eo Bilade, Isisagi, Benoit Bouize, Jennifer Nifekumo, Jelaile Motala, and the rest of them in their fields of specialization. And then to tell you how relevant this is, in Lakomi and Attorney General of Western Nigeria, the court relied heavily on the opinions of scholars in determining the issue of constitutional supremacy over military decrees. In Okonkwo and Okagwe, the Supreme Court relied on the opinions of scholars in determining the legitimacy or otherwise of the custom that took away the right of inheritance from women. This is a very prominent source of law, though of a secondary and persuasive nature. It is also important to note that treaty law is another blossoming source of law in Nigeria. But it is not really a source of law because on its own it cannot stand. For treaty law to be part of Nigerian law, it must comply with the provisions of Section 12 of the Constitution of the Federal Republic of Nigeria, which provides that for a treaty to have legitimacy or effect in Nigeria, that treaty must be domesticated in Nigeria by the National Assembly. So it is not really a source of law, but it is close to a source of law, subject to domestication by the National Assembly. Two main treaties domesticated in Nigeria are the Child Rights Convention, domesticated as the Child Rights Act, and then the African Charter on Human and People's Rights, domesticated as the African Charter on Human and People's Rights, Ratification and Enforcement Act in Nigeria. In Abacha and Fawemi, the courts have ranked the African Charter on Human and People's Rights above local statutes and just under the Constitution of the Federal Republic of Nigeria. It is also important to note that any international convention or statute that has not been domesticated has no force of law in Nigeria. A clear case is domesticated treaties such as the Universal Declaration of Human Rights. They have no force of law in Nigeria. That has been affirmed by our courts in the Registered Trustees of the National Association of Community Health Practitioners of Nigeria and the Medical and Health Workers Union of Nigeria. Once an international treaty has not been domesticated, it has no role to play as a source of law in Nigeria. These are the sources of law in Nigeria. Thank you for investing your time with us. Appreciate it.